A warm welcome to your Understanding Stop and Search session, brought to you by Misuse Equinox. My name is Phil Church and I shall be your narrator and guide for this session. Advertise your business or services within our learning videos. Targeted advertising to our learners. Please contact our team for prices at info@solutionsequinox.com. This presentation is brought to you by Misuse Equinox and SETS channel for online learning, available on YouTube. Like and subscribe for more videos. We all have questions concerning stop and search. We read a lot in the press about stop and search, and many people have strong views on the subject. But what should I know about stop and search? There are a number of powers that the police have in England and Wales to search a person. When we talk about stop and search, we are generally referring to two specific powers. Section 1, Stop and Searches, and Section 23, Misuse of Drugs Act searches. To understand why the police may have used one of the two powers to search you, we must understand what the law says. Section 1 of PACE, Police and Criminal Evidence searches, and Section 23, Misuse of Drugs Act searches. The first thing we need to understand is that Section 1 and Section 23 give a police officer the powers to detain a person in order to search them. This does not mean that you are under arrest. However, you must remain with the officer until the search is complete. The police may use force to search you, especially if you do not comply with the detention of that search. Once the search is complete, the police officer no longer has the power to detain you and you are free to leave. So once the search is complete, as long as nothing has been found and there are no outstanding warrants for you, you are free to leave. Unless you are subsequently arrested for a criminal offence. The police officer must complete a search record and either give you a copy or make one available for you to collect at a later time from the police station, and you can refuse this copy if you so wish. So why has the police officer decided to detain and search me? Well, the answer to this question is connected to suspicion. What is suspicion? This is a very good question. The problem with suspicion is that it is subjective. This means that we all have a different view of what we think is suspicious behaviour, for instance. However, suspicion can never be based on race, the colour of someone's skin, religion, gender, age, sexual orientation, or any other personal characteristics. A good test of whether something or someone is suspicious would be to pose the following theoretical scenario. Were you to describe what you were doing prior to being stopped by the police to an independent group of people, and the general consensus was that the behaviour was suspicious, then this would be a good starting point. The same would equally be true of a police officer. If a police officer was unable to give a good basis for their reasonable grounds of suspicion, then a stop and search may be unlawful. Generalisation and stereotyping should therefore never be factors for the police to decide on whether a person is acting suspiciously. Voluntary searches. The police are not permitted to conduct voluntary searches on a person. The police therefore either have a power to search or they do not. This does not apply to sports grounds where searches may be a condition of entry. Searches are intrusive and could cause embarrassment, so every effort must be made by the police to minimise distress. Searches should be done out of sight where possible, and searches in view may only remove a jacket, outer garment or gloves. Any search that is required beyond those items must be conducted out of sight. A person may be searched by an officer of the opposite sex, but this must not go beyond the outer garments. A search may take place at the location of the stop or nearby. A police officer should communicate clearly what is taking place. When a police officer intends to search a person, they must give the following information. G. Their grounds for stopping that person. O. The object of the search, what they are looking for. W. Warrant. Their warrant card must be shown if not in uniform or if you request it. I. Identity. Their warrant number or name when applicable. S. The station the officer works from. E. Your entitlement to a copy of the search record. L. The legal power being used to search you. And Y. To explain to the person that they are being detained solely for the purposes of a search. These points are not optional. They must be given by the officer, and they can be given to you in any order that the officer wishes to tell you. So they may explain to you at first that you are being detained for a Section 1 search, and so forth. In cases involving suspected terrorists, for their identity, an officer's warrant, collar number or police number may be given rather than their name. The legislation for Section 1 searches. A police officer may detain any person in order to search them or any vehicle or anything in or being carried on that vehicle in any place which the public are able to access. If the police officer has reasonable grounds to suspect that he or she will find stolen or prohibited articles, the police may seize any items they suspect to be stolen or prohibited. A police officer may use this power either in uniform or plain clothes. Where can the police use these powers? Anywhere that is accessible to the public, and that be in factories, restaurants, public transport, cars, scooters, airplanes, boats, football stadiums, gymnasiums, sports centres, parks, swimming pools, and other sporting arenas. The legislation for Section 23 Misuse of Drugs Act searches. A police officer who has reasonable grounds to suspect that any person has in their possession a controlled drug, the officer may detain that person for a search or search any vehicle, vessel where there is suspicion there may be drugs and seize these. If things go wrong, if you feel that the police have treated you unfairly or acted unlawfully, try not to become angry, remain calm and cooperate as much as possible. If you become angry and you lose your calm, you could find yourself arrested under public order offences. Get the details of the officers. You are entitled to make a formal complaint. This should be made to the force who are searching you in the first instance. If you are unsatisfied, further complaint can be made to the IOPC, the Independent Office for Police Conduct. Thank you for listening. Advertise your business or services within our learning videos. Targeted advertising to our learners. Please contact our team for prices at info@solutionsequinox.com.